Hey everyone, Rob Ryder, Sunday, March 18th, 2012. Um, for those of you that could possibly consider that a document such as this, certified copy of record of birth, is actually your certificate showing that you are the owner of a Ponderosa, mine's named Robert Allen Ritluski. It's a landed estate, nothing more than a piece of paper, drop of blood on it. Maybe. But it created a farm. It's considered real property. And so the record is still, according to this, Stephen Toth, clerk of the county of Bay. And notice it didn't say Bay, Michigan. They just said Bay, and the circuit court thereof. Okay, so he's saying he has the record remaining in his office, and the whole thereof. I don't think that this is saying this is the whole thing. He has the whole thing in his office. And this was done as a common law deed because it was recorded. See, it was taken, Liber Book F, page 2137, date of record, October 7th, 1958. So, if you can go with that, and then go with, where is that at? I'm going to find all these things. Right here. We in Michigan have a registration of names of farms. There's the name of my farm, Robert Allen Ritluski. At some point I registered it. I did a video on this last week. So the interesting thing though is, you come down here. Of course you can cancel the registration. When you register something, you go from having rights, title, and interest to just having rights and privileges. That was in here someplace. But that isn't the important stuff. I want to get the stuff I really want to talk about. However, the use of a registered name by others, penalties, civil actions. So basically, nobody can use the name of your farm except the owner, tenant, agent, or employee. So when you register this farm, right, you've picked up some characters, a tenant, an agent, or an employee. But they're the only ones that can use the name of the farm. Robert Allen Ritluski, all caps. A lot of other people try to. Happens every day. Got mail from some of them this week. So, and a farm is an estate. But in English law, and particularly in a description, in a declaration of ejectment, it denotes a leasehold interest for years in any real property and means anything which is held by a person who stands in relation of tenant to the landlord. So they're saying, whoever brings something, are saying that they're your tenant. And they put it in a description of some kind of declaration in ejectment. They're the tenant. You know, they're claiming that they have the proceeds from the land. But are they the tenant? Could it be that they're just a trespasser? Well, last week I was watching a video. Turned out to be from the Montana Freeman. I believe it's Leroy Schweitzer, Mr. Schweitzer was on there, and he said something very profound that I had to go check myself to see, well, could that possibly be? He said the King's Bench is the small claims court. And as odd as that may sound, if you understand that the reality and the fiction are mirror images of each other, then the best court for us would be the lowest court in their system. That's my opinion. You know, one of the things I've always gone with when I'm looking for things. And when he said that, I said, well, damn, yeah, that makes sense. I need to check it out. So I went to this site here. This is Michigan Courts, Small Claims, Self-Help. I'm sure every state has one. Just put in the name of your state, Small Claims, and see what comes up. Google's a wonderful tool. Use it to its fullest. And so in there, it says there's some statute and court rules. And as much as I hate statutes and court rules, I decided to go look at them. And so here they are, right? all these apply to small claims. I wonder what they say. Let's find out. Oh, the Small Claims Division. Chapter 84. The Small Claims Division is created in each district as a division of the district court. Well, damn, district. Sounds bad. This is small d district. I wonder what that might mean. But why this is important, see, we're only at number 1. I'll take you to the meat, then we'll fill in the rest. In number 24, it says actions for fraud, libel, slander, assault, battery, or other intentional torts. All these can be, so the definition of fraud is deceit, deception, trick, artifice. Anyways, these are all common law. This is misprison shit here. These are intentional torts done against the law. Actions of fraud, actions, libel, slander, so forth, shall not be instituted in Small Claims Division. Period. This subsection does not apply to either of the following. Well, I looked at A and it didn't look that good, but I went to B and it looked wonderful. Under this section, under section 73109 of the Natural Resources Environmental Protection Act, MCL 324-73109. It says, the owner of property on which a violation of this part is committed, or his leasee, may bring cause of action against a person who violates this part for $250 or actual property damages, whichever is greater, and the actual reasonable attorney fees. So you can bring it into small claims for fraud if you're the owner of property and there's been a violation on it. Well, yeah, somebody's claiming to be the tenant and brought a charge against the property. But damn, how hard is it going to be to do? Well, let's see. The state court administrator, again, nothing in here is capitalized. The state court administrator shall prepare instruction sheets clearly explaining in plain English how small claims divisions functions, how to commence and defend an action in a small claims division. And someone said, and I think it was Blackstone, that common law must be written in the common language of the time. Has to be in plain English. In addition to general instruction sheets, the state court administrator shall prepare instruction sheets under subsection 1 specifically for actions under the thing we just looked at, for fraud. If you're claiming under this that something's happened, they have a special sheet for it. Commencement of action, filing form, contents of affidavit, notice, name of plaintiff, removal, waiver. An action shall be commenced in Small Claims Division by filing with the clerk or deputy clerk of the district court an affidavit and one copy of the affidavit for each defendant to be served. The form and contents of the affidavit shall be as prescribed by statute and state court administrator. Again, state court, lower stuff. Nothing's capitalized. On the same form as the affidavit, there shall be printed a notice directing the defendant to appear and answer as prescribed in an upcoming section. The full and correct name of the plaintiff shall be given, and the affidavit shall state whether the plaintiff is a corporation, partnership, sole proprietorship, or individual. The plaintiff was acting under an assumed name or business name at the time the claim arose. The assumed name or business name shall be given. Well, the full and correct name, now, I went and looked up what that meant, and to me, when they say full name, they mean your given name, your middle name, and your family name. They didn't call it a surname, they call it a family name. So since I'm not really sure, because I say that I'm Robert Allen, Son of God, created in His image, right? However you need to fill this out, lady, I'm fine with, because as you're going to find out, they're going to fill it out. Now, a sole proprietorship, sole means one, unity. And a proprietorship, well, in Webster's 1828, definition of proprietor, God made man the proprietor of the earth. Or an individual. Now, so a sole proprietorship is a business which has one owner, period. And so, to me, I'm the sole owner of a landed estate. But I'm also an individual, because an individual is one man. The affidavit in boldface shall inform both parties of removal before trial. The right to removal before trial from magistrate's jurisdiction and removal before trial to the General Civil Division. The affidavit shall inform the parties rights waived. They choose to remain in the Small Claims Division. Okay. Well, general is always what I found it to be is when they're doing things in due form of law. So it's not necessarily bad to go to the civil division. In fact, to get out of the system with your body, you have to go to the civil division. You have to get this original writ under the Great Seal from the Court of Chancery, in my opinion. But we can use this, as you're going to see, for a foreclosure, utility bill, everything. Every time somebody has used your name, they've claimed to be the tenant. Well, where's their frickin' franchise says that they are? So the affidavit forms, availability, preparation. This is wonderful. Printed affidavit forms for the commencement of actions in the Small Claims Division shall be available in the office of each clerk and deputy clerk of the district court, who shall prepare such affidavit for a claimant upon request. They're going to fill out the paperwork. Upon filing the affidavit, the clerk or deputy clerk shall cause a copy of the affidavit to be served on the defendant. They're going to serve the defendant. The notice shall be in the form prescribed by the state court administrator. Okay. And this is what they'll do. When and where to appear. That the defendant and plaintiff are to bring all books, papers, and witnesses needed to establish any claim or defense. So we know, again, on a foreclosure, they never signed the damn deed of trust. Right? But we can't get all the papers. Well, guess what? They're going to bring everything in for you. They're going to fill out the paperwork, and then they're going to make these people bring the paperwork in. That the failure to appear may result in judgment against the defendant up to the applicable jurisdiction amount as prescribed by 8401, in which amount claim stated in the affidavit is less, together with the cost of the action. So again, you think small claims has a certain amount. However, in one particular case, it doesn't, and it has to do with land. When somebody stepped on your land, they've committed fraud. I will get back to that in a minute. What all those things mean. That if settled of the dispute was made in the hearing, the defendant may be charged with cost incurred by the plaintiff for initiating the action. Cost has a very, very interesting definition. One of the costs is they have to put up an Americament, is what it's called, or it could be a surety. But when they bring these cases, they have to put these things up, and you're going to claim those because it's a cost you've incurred by having to bring this. So you're going to get their cost. That even if the defendant does not have a legal defense, the defendant may appear to request installment payments pursuant to something. Oh, okay. So, this can be used two different ways, right? I believe that this is the way that they come against us too, because as you're going to see, this is a starting point, and it can go different ways depending on what the action is. But it's used for some kind of trespass. It's a tort. This is a tort court, which is a trespass or a criminal offense. The clerk shall inform the plaintiff and defendant that evenings and Saturday court hours may be made available upon written request and need shown. How many other courts are open at night and on the evenings? Well, the only one I've ever found mentioned is the frickin' land court. We're in the court of land, people. This is where you want to be. This is. the King's Bench. So you got ways for service. Yeah, I'm not going to read all this stuff, but as you can see, as you go through. So let me go back this, though. If you're being kicked out of your house, I talked to a sister on Friday who Skypes me as the sheriff is standing on her house. They're kicking them out of their house. And so she runs down and does a handwritten pleas of the Crown and took it in, I think to the district court is where they ended up sending her, but it was rejected. I don't really know what that means other than, she didn't do it quite right. Or it needs to be done this way. But if we go there with our complaint, they're going to fill the paperwork out for us, and then we tell them we need this as soon as possible. They can stay in the evening and do it on Saturday. Because what's going to happen is if this defendant has to come into court, he's going to be guilty of fraud. He's going to jail. I don't think they're going to want to get in the courtroom and that they're going to settle up immediately. Or if the judge can see by your evidence that you're bringing in that this is unlawful, he can stop it immediately. It's time for an investigation. Okay, appearances, copy of notice of hearings. So, just stuff here. Not less than 15 days, not more than 45. The plaintiff shall appear on the date of the notice hearing, have all books, papers, witnesses necessary to prove their claim. All you need to bring in is this. Or Minnesota Rule 220, an affidavit attached to a vital statistic birth certificate, just claiming that you're the registered owner. Get it under witness. That's evidence. See, evidence needs to be under seal. We need to have our stuff under seal. So everything we're bringing in is going to have a seal on it. Either we're going to go do it as an acknowledgement, whatever it is that you're going to put on paper to say, I am the owner. I am Robert Allen, son of God. Robert Allen Rytlewski is my property. I claim all rights, title, and interest. Get a notary to do an acknowledgement certificate. Take it and get a certificate of authority for the notary. Now it's full proof evidence, due form of law, can be used in any court in the world. It is what it says it is. It's a record, and the only defense is to say the record doesn't exist. And you're going to give them a copy. Okay, so they're going to do this by some kind of certified, so the clerk is going to send it certified mail, return receipt. All right, that's what they do. All right. File a claim of small claims division restrictions. A claim shall not be filed or prosecuted in the small claims division by an assignee of a claim or by third-party beneficiary or third-party beneficiary contract. All right. So it can only be by the person that owns the property. You've assigned it to somebody, but they don't own the property. It's just been assigned. That's what a mortgage is. Now, go back to what a mortgage is. You give somebody a mortgage as simple as saying, when they say to you, well, we'll go ahead and file this for you. You're at the closing table or whatever. Fine, go ahead and file it. Well, by you verbally agreeing to them filing it / deposit, you have given them an equitable mortgage / legal title over the property. But they're not the owner. They just have a mortgage over the property. Well, what's the conditions of the mortgage? On a piece of real estate, they're saying that you owe them money, but they never signed the deed of trust, so you can't owe them any money. What, they didn't owe you any money, then why do they still have the papers? These people are going to make them bring them in. The papers we've been looking for. With the securities that go with them, all the books, papers, everything, the defendant has to produce them. A person shall not file a claim on behalf of sole proprietorship or partnership unless the person is the proprietor. That makes sense. And that has some caveats. At the end of the day, I think we can get their officers to even, here we go. Parties representation, request for trial before district court. So an attorney at law, except in attorney's own behalf, so only on his own behalf, collection agency or employee or person other than the plaintiff and defendant, except as otherwise provided in this chapter, shall not take part in the filing, prosecution, defense. So if you're not involved, you can't be involved. Right? A sole proprietorship, partnership, or corporation as a plaintiff or defendant may be represented by an officer or employee who has direct personal knowledge of the facts in dispute. If the officer or employee who has direct and personal knowledge of the facts in dispute is no longer employed by the defendant or plaintiff or is medically unavailable, the representation may be made by that person's supervisor or by the sole proprietor, a partner, or an officer or a member of the board of directors of a corporation, or an officer, or a member. So, all these people have taken an oath to us, the kings. They're all officers, right? So I should be able to get a prosecutor to prosecute this for me. Or counsel. And somewhere here it says we have the right to counsel. It didn't say a privilege, it's a right. So I want my counsel. Okay, I'm not going to read that. Before the commencement of trial, the plaintiff or defendant may, upon demand, require that the trial be conducted before the district court judge and not a magistrate. All right, so you open the case, and now before the commencement of the trial, the plaintiff or defendant, upon demand, may require that the trial be conducted before a district court judge. Now we can move to a different court. Or may remove the case from a small claims division to the general civil division of the district court. Settlement, payment of judgment, execution, garnishment, warning. See, it's talking about garnishments, right? People get garnished all the time. Well, a garnishment must have happened through this court. Before at the hearing, the parties may make a settlement upon those terms as they may agree. There you go. How much you want to bet they're going to settle and not come to court before the hearing? The settlement shall be in writing and signed by both parties. Upon filing the settlement with the court, the judge shall review the settlement, and may enter it as a judgment of the court, or may require that a full hearing take place. So if they're trying to screw you, he's going to say, I ain't doing that. No, we'll go ahead and have the hearing. He's going to make sure you don't get screwed. The judge shall order that the judgment in a small claims division shall be satisfied by payment to the clerk or the plaintiff, either in lump sum or in installments, in the amounts and times as the judge considers just and reasonable under the circumstances. See, I think when they do this to us, we go pay the clerk. However, when they do it to us and we catch them, the judge going to pay the plaintiff, pay us. For a good cause, see, here we go, good cause shown. So a show cause hearing, well, what are they looking for? A good cause. For a good cause shown, the judge may reinstate an installment payment, judgment, previously not mentioned, or a judge may alter the amount of the installment payment and time of payment, authorize execution, attachment of garnishments, and shall authorize execution, attachment, or garnishments to issues where it appears that the defendant was not paid according to the terms of the judgment. I think we could use that for something. The judgment shall include a warning that the defendant's failure to pay the judgment pursuant to its terms or any installment payment ordered may result in execution against the defendant's property. The defendant may be compelled to appear for an examination of the defendant's assets. Woo-hoo. Good for us. If the defendant is not present when the judgment is entered, or is present but does not immediately pay the full amount of the judgment when the treatment is entered, when the judgment is entered, the judge shall order that the defendant within 30 days after the day of the entry of the judgment may pay the judgment in full or disclose in writing to the plaintiff and the court his or her place of employment and location of his or her accounts in state or federally chartered banks, savings, and loans. All right, so where you got your cash? A copy of the judgment shall be given to the court, delivered, or immediately mailed to the plaintiff and defendant following entry of the judgment. A writ of garnishment as periodic payments. Okay, well, so that's more about that. Removal of waiver hearings, manner of conducting no jury or verbatim record. Before the commencement of the trial in a small claims division, the district court judge or magistrate, because we've been given the choice now to put it before the judge or keep it with the magistrate, shall inform both parties orally or in writing of the right to remove before trial to a general civil division, and all of the rights waived if they choose to remain in the small claims division. And all rights waived. So they got to tell you all the rights you're going to waive if you keep it there. So do you want to move it to the general civil? Well, ask them. What rights am I giving up by leaving it here? In small claims. In hearings, because I don't know that we're losing any. Be honest, I don't know. But you're going to accept their oath and they're going to tell you. In hearings before small claims division, witnesses shall be sworn. Isn't that wonderful? See, this is why I think we want to keep it where it is. Small claims division, witnesses shall be sworn. See, this is what they do to us, right? They start it here and then they take it into these other courts and it becomes a civil matter. So, like a special proceeding, is called that because it's not a general proceeding, and a general proceeding is in due form of law. General usually means, like to me, due form of law. And special, since it's not general, means it's not due form of law. They've modified the term. In hearings, so they may be sworn, the judge shall conduct the trial in an informal manner so as to do substantial, we love substantial, justice between the parties, according to the rules of substantive law, love that, but shall not be bound by statutory provisions or rules of practice, procedure, pleading, evidence, except provisions relating to privileged communications. The sole object of such trial is to dispense expeditious justice between the parties. There should be no jury, nor shall a verbatim record of such proceeding be made. All right, so there's not going to be a jury, and it won't be a verbatim record, and courts of record don't have verbatim records. If you go read the stuff they put into the record, it was mainly what the charge was and what the remedy was, but not everything that happened in between. You know, that's the minutes that they're doing. That's not the record. A record's just really what the charge was and what the answer was. Unless a party removes small claims action to the district court pursuant to some section, all parties in the action in small claims division shall be considered to have waived the right to counsel. All parties to an action in small claims division shall be considered to have waived the right to counsel. Okay, so now it's like, okay, well, yeah, I want counsel. I want a counsel expert in real estate law because that's what we're going after. Somebody's trespassed on my farm. I want the very best attorney I can have. I've already paid for them as far as I'm concerned. They're already hired. They're called prosecutors. So, that's one of the things we need to ask them. Okay, I want my right to counsel. I demand my right to counsel. Didn't say I had to pay for them. I said it's a right. It's one of my God-given rights. So, maybe we do want to start in small claims and move to district. Now, again, the reason for this, when you get bigger than the house and think about your body, is eventually we're going to go in and say and claim rights, title, and interest to our body. And that's going to generate a writ. And hopefully that writ's under the Great Seal from the Court of Chancery. But then you have to have a counsel to take it into the Court of Common Pleas to do this hearing for you. I think that's how it works. But I know a lot of people, you got other problems today. Your house, your car bill, your utility bill, all these things where people have used your name. Well, they violated the law. Unless they're the tenant, have proof that they're the tenant, they've stolen your stuff. In the Bible, it says a man can walk through your field and have something to eat. No big deal. But he can't take any with him. Right? He can't carry away any of the profits. That's what they're doing in your farm. They're entering your farm and carrying off the profits. All judgments of small claim division shall be conclusive on the plaintiff and defendant and shall be in a form prescribed by the Supreme Court. Again, small Supreme Court. Beautiful. And conclusive. Shall be conclusive. I mean, these are powerful words. They're not bullshitting around here, folks. We're using real strong words with particular meanings. I'm not going to argue with it. Venue of actions, except as provided in 3 and 4, the district of first class actions. So I don't know what a first class action is. I have to look that up yet. Filed in the county which the cause of action arose. Right? So you don't need to do this in your birth county, right? If you're taking care of your house where you're at, well, that's the county you do it. Utility bill, that's where you do it. If they're sending the mail to you at that address, well, that's the county you're going to go to. If the venue of an action is proper under this section at the time the action is filed in a small claims division and a party removes the action to the general civil division of the district court as provided by law or court rule, the court shall not order a change of venue of the action because the venue in which the action was filed would not have been proper if the action would have been filed in the general civil division of the district court. The court may order a change of venue for the action as otherwise required or permitted by court rule. So if the venue of an action is proper under this section at the time the action is filed, so it's proper for us to go in common law and complain about trespass, and a party removes the action to the general civil division of the district court as provided by law, the court shall not order a change of venue of the action because the venue in which the action was filed would not have been proper if the action would have been filed general civil division of the district court. So, yes, we had to go to this court first to go to that court. We couldn't go to the general civil division directly. First, we had to go to small claims, and then you can move it to the general civil and keep it in due form of law. Now it's general civil case. It's going to follow due form of law. And you do have superior rights, title, and interest. You have the frickin', it's you that has the owner papers. You may be a registered owner, right? And I'm not saying that's good, but you're still the frickin' owner. You're just registered. We need to go get our property back because our tenant ain't doing it. Location of small claims division. Filing claims after filing of claims after regular court hours. Scheduling of small claims hearings. You can even file your claims after hours. The small claims division of the district court shall sit at least once each 30 days at a location at which the district court is required to sit pursuant to some other section. A clerk or deputy of the district may be available for filing of claims with the small claims division after regular court hours at the discretion of the presiding judge. Scheduling of small claims hearings shall be done to lessen as much as possible the time that is necessary for the plaintiff or defendant to be absent from employment. A judge of the district court may be available to hear small claims after regular court hours if the presiding judge determines evening hours will facilitate the adjudication of the small claims cases. Forms and stationery. A fee of the following amount as applicable shall be charged and collected for the filing of an affidavit for commencement of actions. Well, ask him if a living man pays. Say, is it applicable for the king to pay for anything? A fee charged shall not be collected by officer rendered. Okay, well, this is just about fees, no big deal. Something to look at again later, but I'm trying to get this thing done. Cost to prevailing party. The prevailing party in any action in a small claims division is entitled to cost of the action and also cost of execution upon judgment rendered therein. The cost shall include cost of service, notice of appearance of the defendant. Well, there's other cost that they're not talking about, because another cost is this americament, the security that the plaintiff had to bring in to bring the charge in the first place. Because if he loses, it goes to you. Counterclaim. If the defendant files a verified answer stating any new matter which constitutes a counterclaim, the court may grant continuance upon request of either party. This is what we should be doing maybe in some of our cases. We're going to counterclaim their claim. Stating any new matter which constitutes counterclaim. Well, I just noticed they never signed the damn paperwork. A separate action by defendant, transmittal fees. So if a defendant in a small claims action has a claim against the plaintiff, which claim is for the amount over the jurisdiction of the small claims division, but not of a nature which would be subject to a counterclaim in accordance with the rules of the Supreme Court, he may commence an action against the plaintiff in a court of competent jurisdiction and file with the clerk or deputy clerk of the small claims division wherein the plaintiff has commenced his action, at or before the time set for trial of small claims action. An affidavit in the form prescribed by the Supreme Court setting forth the fact of the commencement of such action by the defendant. So, I think that no matter what court it's being heard in, because they all started under the same thing, under small claims, that when they're foreclosing on you and you're the defendant, right, they've come at you as the plaintiff. Well, now you can go ahead and do a separate action on them for what they're doing to you. And he may commence an action against the plaintiff in a court of competent jurisdiction and file the clerk or deputy clerk, small claims division. So again, I think that this small claims, they're saying you can take it to the small claims division to do this because it is a court of competent jurisdiction. It's a frickin' land court. So that's where I think we should take it to. He shall attach the affidavit, a true copy of a complaint filed by him against the plaintiff. Okay? And pay to the clerk or deputy clerk a sum of $1 for a transmittal fee, and shall mail to the plaintiff a copy of the affidavit and complaint at or before the time above stated. So really, this is what we should be doing the very first time they send us paperwork. So that's my property. What are you doing with it? I'm going to bring an action against you for bringing an action against me. So this would be early on when they first start sending you paperwork where somebody is charging you with a court case, right? Well, our answer is to go back with an affidavit and a complaint and give it to these people and then send a copy to the plaintiff. This is like doing the pleas of the crown right here. The plaintiff in a small claims action shall not be required to pay the clerk of the court for which the action is transferred any transmittal, appearance, or filing fee. Okay, so a plaintiff in a small claims action shall not be required to pay the clerk of the court to which the action is transferred any transmittal, appearance, or filing fee in the action. Okay, so if we take it into small claims as the plaintiff and we move it through these other courts to get it to where we need it to be, there is no charge for us to have that done. It's free. Oh, and here's that one: actions for fraud, libel, slander, assault. Right? like libel and slander, that's against your character, as Mr. Schweitzer said. Not so much your status, but your character, right? I'm a son of God, and I'm the owner, and you're saying that you're my tenant. And this tells where to go look. A county, city, village, township, local, intermediate school may file an action in small claims division. An action may be filed in small claims division against a county, city, village, township, or local or intermediate school district but a party may not assert a claim with respect to which the county, city, village, township, or local intermediate school district has immunity. Well, they don't have any immunity from you as a king. They work for you. Limitation on claim or recovery. Amendment increasing amount claimed. A person having claimed in excess of the applicable jurisdiction amount as prescribed in 8401 may institute an action in the small claims division, but may not claim or recover more than the jurisdictional amount. So, how much farther down is that? However, it says under this, I'm going to get myself lost. Okay, I have to cover that when I get to the back, get to the end. Okay. Okay, so, so we need to ask, well, what's the jurisdictional amount? Just so we know for sure. Remember, they're saying that this clerk is going to fill the paperwork out for you. They're acting almost like your counselor. Use them like one. What should I do? This is what I want done. I want my house back. I want my escrow back. I want everything that had to do with this title deed that I have accepted the deed, and this piece of paper called a deed of trust that the beneficiaries never signed. If an action properly commenced in a small claims division is removed to the district okay, so if you're going to move it, either party may amend his or her pleadings to increase the amount claimed upon payment of any difference in the applicable filing fee. Okay, so this is what they're doing to you. They bring you into this court, and then they remove it to this other court, and once they do, they can increase the amount claimed upon payment of the difference, of any difference in the filing fee. So they bring you in for next to nothing on a trespass, then they take it here, and now they can increase the amount claimed. Name in which the defendant sued. An individual, sole proprietorship, partnership. Name in which defendant sued. Validity of judgment. Okay. An individual, sole proprietorship, partnership, corporation may be sued in small claims division in any name used in any advertisement, sign, invoice, sales slip, register tape, business card, contract, or other communications or document published, displayed, or issued to the public in the course of its business. So you take your frickin' electric bill down, and mine's Consumers Energy. So that's who I can call the defendant. I can call them the name of whatever they're using. Conduct small claims hearing by district judge or magistrate appeal. A small claims hearing may be conducted either by a district court judge or by a district court magistrate, who is an attorney licensed to practice in the state and who is authorized to do so by the chief judge of the district as provided in 80-514. I'd be asking if I can appoint him as my pocket sheriff. If that hearing is conducted by a district court magistrate upon appeal, new trial may be taken into part. Small claims division of the district court appeal shall be taken within 7 days after the entry of the decision of the magistrate. Further appeal for judgment of the district court shall not be available to either party. Okay. All right. So this is where it talked about that one. I got the. Okay. So anyways, we're talking about this 1990 or 1994 PA 451 MCL 374 yada yada yada. Well, here's some more of it. So, in that same section of that statute, it has some definitions, and it defines farm product means that term as defined in Section 2 of Michigan Right to Farm Act. A farm property means land used in the production of farm product and all lands contained within. So it's property. And this thing here said, the owner of property. Farm property. The owner of property in which a violation of this part is committed, his or her leasee may bring cause of action against a person who violates this part for $250 or actual property damage. So how much did they take out of your orchard? How many apples they walk off with? Hell, they send you a number every day how many they grabbed. And this says, okay, so this thing is referencing this. Farm means the land, plants and animals. Buildings including ponds used for agriculture, aquatic activities, machinery. Okay. Farm product means those plants and animals useful to human being produced by agriculture and includes, but not limited to, forage, side crops, grains, feed crops, yada, 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 yada. Okay. Then, where did I see? Up here. Farm means the land, plants, and animals. Well, what are protected animals means a term defined by 40. I have to go look and see what that is. See, I want to see if a human's considered a protected animal. I didn't look that up yet, I don't think. Oh, protected or protected animal means an animal of a kind of animal that is designated by the department as an animal that shall not be taken. Well, natural resources. So, in this long thing of game animals, they came to protected animals, and this is what it said. All right, so everything else was game, and then I guess the rest of them shall not be taken. So, then when you go to this site, right, so what I really just read you was this MCL 8401, 8427. This 68302 is this one. Equitable jurisdiction and authority, injunctive order rescinding the reforming contract, equitable claims, judgment order, in addition to the civil jurisdiction provided in these other sections, the district court has equitable jurisdiction and authority concurrent with that of the circuit court. So it has equitable jurisdiction, equity, and authority. Authority means law, because that's the circuit court is the court of law in matters to the extent provided by the section. In cases brought under Chapter 84, which was small claims, what we just read. So the district court has equitable jurisdiction from the exchequer and also law, common law, from the circuit court. So this district court, Chief Justice of the district court is, in my opinion, the chancellor. He has jurisdiction over the Court of Chancery. He has jurisdiction over the Exchequer, Court of Equity. He has jurisdiction over common law. Okay, and in actions, okay, so in those, right? Well, then in these other ones, summary proceedings. That's what they're coming after you for. Anything that's a summary judgment, whatever, it was a summary proceeding. Well, go look what that means. It's not a general proceeding. If it don't say general, it's not due formal law. Foreclosure of mortgages and land contracts. Well, here's the things they're doing to us daily. Right? Well, we're going to use this one here under 84 to get our stuff back because they're putting claims against your landed estate. summary proceeding to recover possession of premises. Right? They're putting a claim on it, and all we need to do is rebut their claims. Okay, and a couple other ones that it's under. So I haven't really read that too closely yet, but my main thing was that it looks like absolutely that we want to take our business to this court, small claims court. If Michigan has this written, you guys are going to have the same thing. I don't know where they hid yours, but specifically on an action under 73-109, which has to do with somebody violating your land. And your land is your Ponderosa, your property, your landed estate. I'm going to leave it at that. I got to say this myself a little bit more because I plan on putting it to use next week. But I just read it for the first time last night. I've done this much highlighting to get an idea what it says, but I got a lot of things to check out yet. But I know that if you're losing your house, go down and talk to them now. Go to small claims and tell them that you need to talk to them about doing something under whatever your section is in your state. They got a specific form for it. It says right here. And they're going to fill the damn forms out for you. All right, enough of that. See y'all. Take care.